The ayes have it. Clerk.
General business orders of the day for the consideration of private senators' bills. Number 23, Trade and Foreign Investment Protecting the Public Interest Bill 2014, resumption of second reading debate.
Senator Whish-Wilson.
Thank you, President. This is a very important piece of legislation in front of the Senate today. It's a bill about restricting the power of corporations to sue and harass sovereign governments in how they go about enacting legislation on behalf of the Australian people or their nations all around the world. It's about giving Parliament and parliamentarians a say in our democracy and some influence over secret trade deals. It's about helping take politics out of our secret trade deals. But mostly, it's about protecting our democracy, our sovereignty as a nation, the environment, workers, and bringing much-needed balance back to the trade debate. It's about giving power back to communities. But lastly, to me personally, who brought the bill to the Senate, it's making a statement about the kind of society that we want to live in. Now, investor-state dispute settlement clauses are one of two types of dispute resolution mechanisms in modern trade deals. We have state-to-state dispute mechanisms where a country can turn around and take action against a breach of a trade deal against another government, or private investors can take their own personal action against a government through shady, secret arbitration panels. Essentially, what we have set up in our modern trade deals is a parallel system of governance that gives corporations the right and the ability to impinge directly upon our ability as parliamentarians to enact legislation in the public interest. And they do this if they feel that a government policy or a change in policy has directly affected their profitability or their investment. And I'll get to that more in a minute. This is not just an issue that the Greens are trying to raise the profile on in Australia. And may I say, a number of other stakeholders in this country are trying to raise the profile of this issue. Civil society has been talking about this issue for a number of years. And while Senator McDonald's in the chamber, he would well remember, through you, Acting Deputy President, he remember this debate back in 2004 around the US-Australia free trade deal, when his government, under John Howard, refused to sign on to investor-state dispute settlement clauses in their free trade deal with the US. May I say, for a very good reason that Senator McDonald no doubt knows very well about. This is not just an issue in Australian society, it is an enormous issue all around the world. I got visited by the French consulate on this bill. They came to consult with me and find out more about why we were introducing this bill, and they said that ISDS, investor-state dispute clauses, had made the front page of both national French newspapers 2 days in a row. 2 days in a row, on the back of riots in Europe on this issue. The appointment of the Trade Commissioner in Europe and her wanting to leave ISDS clauses out of their negotiated agreements with US free trade agreements across the Atlantic has led to a fracturing of politics in Europe. This is a hugely contentious issue, whether these clauses are allowed in modern trade deals. And in the US, it is also an enormous political issue. We put this bill to Parliament, and it's gone to Senate inquiry, because we wanted to raise the level of national debate around the inclusion of such clauses in modern trade deals. And I was very grateful when the High Court Chief Justice French wrote a paper on this bill, partly on this bill and around this bill, saying this country needed, especially the legal fraternity, needed to have a national debate on whether these clauses were included in trade deals. Now, while I was away on holidays, I went on a surfing trip to Indonesia. I was only able to take a couple of small books with me, but I did take a political essay by Laura Tingle called Great Expectations. And it talked about the disconnect in this country between the Australian public and politicians, and why politicians were held in such low esteem by the Australian public. And it explored lots of reasons why the Australian voters and Australian public felt that politicians and parliamentarians had lost control of various agendas, particularly in a world of globalisation. And it talked about a growing sense of anxiety and alienation in our community, and why people were feeling this sense of loss of power over their own lives. And it was an excellent expose of some of the deeper underlying issues in our society. And this loss of control, this perception and real feeling of loss of control that people have in this country, I personally have never felt that as acutely as when I've been talking to people about the free trade debate. Now, this is no secret. Free trade negotiations have been going on for decades, and they've always attracted controversy because the increased opening up of our economies and globalisation of our society has led to very significant changes across our laws, our institutions, our regulations, and of course across our communities. And this is an issue that now, as we get further and further and deeper into opening our economies, is becoming more acute, because what we've got left to trade is a lot more sensitive, and it is a significant matter of public interest, as I said, right around the world. The Trans-Pacific Partnership Agreement is one example. The largest trade deal this country is negotiating, 40% of GDP. Minister Robb, on the weekend, dismissed the concerns of civil society. And may I say, having been through the Senate inquiries on this, not just civil society, dismissed the concerns of the Productivity Commission and a number of very conservative commentators around the way trade deals are done, negotiated in secret, and about the inclusion of things such as investor-state dispute settlement clauses. And he dismissed these too easily and too quickly. And it seems that perhaps Laura Tingle's right, that a number of politicians and parliamentarians are out of touch with the way the Australian public are feeling and the decisions that we make in this House about things that directly impact their future. Well, what is it about free trade deals that cause anxiety, mistrust and frustration amongst the Australian community? Well, I think they realise, and they've looked at the track record, that negotiations involve trade-offs. You have to give up something to get something. Yet it's only sold to them that somehow these deals are beneficial. There's always costs to trade deals. There has to be, by definition. Every textbook you pick up as a university student, it talks about this. But we only ever hear about the wins. We only ever hear about the increased agricultural access. But they can see over the years the changes to their communities and to society. We've seen the collapse of the car industry. I believe one of the reasons that the Korean Free Trade Deal wasn't finalised by the previous Labor government was that they knew it would be the straw that broke the camel's back with the car industry. They also knew, the Labor Party, that it would involve signing ISDS clauses. And we had evidence during JSCOT from a number of stakeholders that the ISDS clause was what had prevented this deal from being signed, because Labor had taken a very strong view on including these undemocratic and dangerous provisions in trade deals. But unfortunately, it looks like Labor will vote for the Korean Free Trade Deal with ISDS, but I'll get to that in a minute. This debate about trade, who picks the winners? If we have trade-offs in negotiations, who actually picks the winners? How highly politicised is it from the minister and the executive, who control the trade deals and are the only ones who know what's going on behind closed doors? How politicised is this process in picking winners if the power always lies with the executive? The secrecy is a very serious issue, and as I said, not just for the Greens and for civil society, the Productivity Commission themselves have consistently raised the lack of transparency around trade deals as being a serious issue. The Chamber of Commerce and Industry, the Australian Chamber of Commerce and Industry themselves, said there's no need for the secrecy and lack of transparency, and that we should be looking at totally redoing our trade negotiation process in this country. Parliament has no oversight in the decisions that are made behind these closed doors. But when the final text has been signed and is in train by the government, the media machines working overtime to sell these so-called benefits of free trade deals, then we get to scrutinise them. But by that stage, it's too late. You either vote against it because there's things you don't like about the trade deal, such as the inclusion of ISDS, or you vote for it. You can't change them. As I said yesterday, it's take it lock, stock, or get two smoking barrels straight in the face. Stand in front of a speeding train. You're anti-economics, you're anti-Australian, you're anti-economy, when you've got very serious, justified issues about these trade deals, their outcomes and the way they're negotiated. The influence of foreigners, foreign countries and their agendas, the stakeholders behind trade deals. We think trade deals are all about governments negotiating in our names, but actually behind those government negotiators are special interests, mostly corporate interests. So these decisions, and let me tell you, trade and free trade deals are about deregulation. That is what they're about. They are about deregulation. And they're about business agendas. And coming back to this feeling of anxiety that we have in our community about the role of government, many people see these trade deals as corporate takeover of our country, our institutions and our government by stealth. By stealth because they're conducted in secrecy. Now, we need to change the way we do trade deals in this country, but try and understand that trade deals themselves and the way and the emphasis we put on trade has changed considerably over the decades that we've been opening our economy. Trade deals now are less about putting things on ships, really tangible concepts that Australians understand, selling iron ore, selling beef, wine, importing cars. Trade deals today are more about services and promoting services, the future of trade deals, such as the Trade in Services Agreement that's been negotiated, and they're about investment and protecting direct foreign investment in different countries. And of course, these deals rely on synchronising laws and regulations between countries. That's what they are now. By default, they are about synchronising laws and regulations between countries. And in whose interest? In the interest of US multinationals? 23 out of the 29 chapters in the Trans-Pacific Partnership Agreement don't relate to trade the way we traditionally understand it. They're all about changing laws and regulations between countries, synchronising and standardising laws and regulations. These are significant matters of public interest in a whole range of different areas. Local content for media, the environment, the ability to have moratoriums and have flexibility in environmental policy, labour and working standards, pharmaceutical, access to healthcare policy. All these things are being done in secret. I want to debunk some of the arguments against this bill and removing ISDS, that somehow they've been around for a long time and that we're very comfortable with them. Well, guess what? They are proliferating. 10 years ago, there was only a dozen ISDS cases around the world. Now there's nearly 600. There's nearly 600 because the nature of trade deals are changing. This is about protecting direct foreign investment in different countries. And it's not just first world countries that have cases brought against them, such as the Australian government by Philip Morris, an aggressive tobacco company trying to change a health policy in this country, trying to intimidate our government, sending a strategic message across the world that if you're a third world country, don't you dare change packaging regulations. That impacts our profits. We will sue you. We will spend whatever it takes to achieve that outcome. This is what got Chief Justice French involved in this debate. And by the way, Philip Morris is suing the government in Guatemala for doing the same thing. And there's a number of other cases against Australia through the WTO for trying to change a health regulation in this country. This is an example of aggressive corporations trying to sue governments. These deals have been around, these ISDS clauses have been around for 20, 30 years. They were about simply expropriation of assets. But now there is significant shades of grey about what powers corporations have and their ability to bring cases against governments. We have so-called carve-outs and exceptions now written into these clauses. Do they work? Well, not according to nearly all the experts around the world. The evidence presented to the committee on this bill is that they don't work. They certainly don't stop litigation like the Philip Morris litigation being brought against the government, which we know causes regulatory chilling and is a very simple ability for a corporation to put pressure on sovereign governments not to bring in legislation. We don't even know how many threats there's been behind the scenes. There's been an excellent study done, well, actually an excellent expose done by the ABC in background briefing that goes for 45 minutes that comprehensively covers all the issues on ISDS. And they interviewed an expert who'd been consulting the UK government, Toby Landau, and he talked in detail about all the cases where he'd been working as a consultant for the UK government around the potential to be sued if they brought in policy. He said it's a very real risk that has to be taken into account now by our public servants and our parliamentarians, or should I say our politicians, when they bring in policy. You have to consult on this stuff now. This is us giving corporations a right to sue sovereign governments if they disagree with our policies. And we know that from some of the outcomes we've seen around the world, these can lead to billions of dollars, tens of billions of dollars worth of losses to taxpayers and citizens in those countries. And a country such as El Salvador, which is being sued by Oceana Gold, an Australian-based company out of Melbourne, for $300 million because they had a mining licence revoked on them, because there was issues around corrupted process and environmental damage. They're not just suing for the money they've sunk into their exploration, they're suing for lost income, $300 million. My understanding is that's half the education budget of El Salvador. Half the education budget. So these carve-outs and exceptions, for anyone who says that we can have these deals now, that we can safely include them in trade deals, go and read a publication recently that the EU commissioned with hundreds of the best legal minds in the world on this, saying do not include these clauses in trade deals, which, by the way, is exactly what the Productivity Commission said in Australia. Do not include these clauses in trade deals. They bring no benefits. There's no evidence of any increased flows in direct foreign investment across borders. No evidence that it increases trade, but there is plenty of evidence that it significantly brings in risks into any country that does have these deals. That is why John Howard didn't sign up to it. That is why the Labor Party refused to sign up to deals that included ISDS. Now we have the CAFTA, the Korean Free Trade legislation, coming to the Senate shortly, and it includes ISDS. Labor voted for it in the lower house, and will they vote for it in the Senate? If they vote for CAFTA with the government, who's clearly changed their tune on this as well, then what do we do for the Trans-Pacific Partnership Agreement? The biggest trade deal in this country's history, that in this case has US companies involved, who are the most litigious. The statistics are simple. Who are the most litigious investors who use investor-state dispute settlement clauses. And it's not just Australia I'm worried about. I'm worried about the impact on other countries in our region who are poorer, who don't have the money that first world countries have, having their environmental or labour standard policies impacted by aggressive corporations who are trying to protect their profits and their shareholders. And I'd say to the Labor senators, if you want a good expose on this, print out Melissa Park's article in The Guardian yesterday. An excellent article on why we shouldn't have ISDS clauses in trade deals. And just get up here and read it. It is a really good, well-written article. She understands that including these in trade deals will open a can of worms. And I would say to the Liberal senators, have a look at the printout from the DFAT website 10 years ago when John Howard refused to include these in trade deals. It clearly says we don't need them, we have strong political institutions in America and Australia, and that these things will be negotiated if they're needed. Well, what's changed in 10 years? We're still doing a lot of business with the US, as we are with Korea. We don't have these in place now. Why do we need them for the future? They are unnecessary and they present significant risks. Let's make a strong, visible decision today to protect our government's ability to legislate in the public interest, protect our sovereignty, protect our communities, our workers and our environment. In other words, let's protect the public interest. Let's send a message to the Australian people that we do have control, that we will stand up for them. And today I ask the Senate to vote for the bill. Let's wrestle back power and allow the Australian people to at least start wrestling back power and an influence over their own future and the lives of their communities. Let's not weaken our democracy. Let's make a very visible stand today and implement this bill and set an international standard.
Thank you, Senator Whish-Wilson.